As buildings age, seasons change, and work needs to be done. Condominiums try to hire qualified vendors to perform that work. Whenever a vendor is hired, they promise to do something in return for something, such as a payment. That is a contract. Hello, my name is Henry Goodman, and I'm with the law firm of Goodman, Shapiro, and Lombardi, with offices in Dedham, Massachusetts, and Lincoln, Rhode Island. For over 40 years, we have performed work involving condominium associations and have concentrated in that area. We do work in Rhode Island, Massachusetts, and New Hampshire. This session deals with some important concepts involved in the contracting process, such as proposals, bids, basic needs, and pitfalls. While this session uses labor and materials contracts as its guide, the principles discussed can also be applied to other contracting processes, such as your management contracts, employee contracts, and professional arrangements. At this point, I would like to turn this over to my partner, Ellen Shapiro, who will discuss bidding and proposals for work.
When you are ready to find a person or company to perform work, it is usually a good idea to put the work out to bid so that you can find a responsible contractor who will offer you the best price for the job. But before we delve into some technical matters, let me say from the very beginning, unless your documents require it, there is no legal requirement to get 3 or more bids. However, it is best practices to get as many bids as are reasonable to find the most responsible contractor to do the work, again, at the best price. There are a couple of concepts in this search. One, of course, is price. However, of even greater importance is the term responsible contractor. The person with the lowest price is not always the best, and in fact may not even be responsible. Thus, you are looking for the best price from a very good contractor. The other important thing to remember about the bidding process is that the association should give out an invitation to bid which contains fairly complete specifications. If you merely give out an invitation to bid on a specific job, such as snow removal, without any specifications, one contractor may bid with salt and sand applications and another may not. Thus, you're going to get different services, qualities, and prices from each of them, but they're not bidding on the same thing. It's like the old adage, you're comparing apples and oranges. You will be doing yourself and your community a disservice. Finally, it isn't necessary to put your contracts out to bid every year. If you find a contractor who is reliable and competitive as shown by prices and work in the past, that contractor may very well know what you want, know the property, and be very familiar with the ins and outs of the services that are required. There is value in keeping that contractor for the service without putting the contract out to bid. However, it ought to go out to bid every so often just to keep him honest and his pencil sharpened in your favor. I would like to turn over the next part of this presentation to my partner, Frank Lombardi. Frank is the partner who manages our Rhode Island office, and he is going to speak to you about contracts.
So let us move on to contracts. Keep in mind that any contract handed to you by a contractor probably is slanted in favor of that contractor and will need to be revised to make it more fair. Now, some contractors will insist on only using their own contract, or they'll not do the work. In that case, you have to decide whether to knuckle under and accept their contract or negotiate a more fair contract with yourself. An oral contract for over $500 is usually unenforceable unless one of the parties has partially performed their side of it. Then they may be entitled to the fair value of what they have done, which, if there's a disagreement as to the amount, may be more or less than what was actually agreed to. Because of the difficulties in proving what was said and by whom, we discourage oral contracts and insist on a writing to memorialize the agreement.
Larger contractors, or your own architects or engineers, may use the AIA, or American Institute of Architects form, or some other long form of contract. While these contracts may contain many important and necessary clauses, and they are in fact often overkill, be aware that they also need tailoring. First, they contain many unnecessary clauses, and second, they are slanted in favor of the design professionals as well as the contractors and need to be amended. However, they may make reference to the bid specifications and require that those specifications control the situation in the event of a conflict. If they do not say that, they should, unless you have changed the specifications as a part of the bidding process. You should avoid conflicts of interest. Rumor and suspicion, especially when unfounded, are the undoing of many a good person. Try not to hire a contractor who appears to have a close relationship with management or a board member. In that way, you avoid claims of nepotism, favoritism, payoffs, and unfair protection or cover-ups. And now I'll turn this back to Ellen to speak about basic needs in a contract.
Every contract should identify the parties. By identify the parties, I mean their names, their addresses, and their legal status, such as a corporation or a trust. What is the contract price? That should be in there as well. The payment schedule. Will there be a holdback? And if so, what are the terms of the holdback? There should be a clause identifying where official notices are to be given. If a contractor is to be licensed, such as a plumber or a construction contractor, what type of license do they have? What is their license number? Where are they licensed? And ideally, you should have a copy of their current license. If permits for the job are required, who is going to obtain the permits? Who is going to pay for them? Very often, contractors will obtain them, but the party for whom the work is being performed pays for them. This is a subject of negotiation in many contracts. What is the nature of the job and the specifications in as much detail as possible? Will there be a person whose arbitrary decision controls the job, such as a clerk of the works or an owner's representative, and who should it be? Will it be a property manager, an architect, the engineer, or someone else? A statement as to whether the contractor can subcontract the job or any portion of it, and whether your permission is required before it is subcontracted. The contract should also discuss licensing and insurance requirements for the subcontractor and payment provisions to avoid subcontractor liens in the event the sub isn't paid by the primary contractor. The commencement and termination dates and any penalties, if appropriate, for non-timely performance, as well as a provision governing excusable delays. Acknowledgement that the work is being performed in a residential or commercial setting with appropriate start and stop times each day. Restrictions on weekend work, restrictions on noise, appropriate dress and language, provisions for toilet facilities, provision for change orders and unexpected contingencies, such as the discovery of quicksand or ledge. Where are the materials going to be stored? Will the site be cleaned up at the end of each day, such as the nails and debris? Will the site be kept clean? What about repair of any damages to the property? What about the parking of workers and their construction vehicles? Finally, while we all hope that contracts will go smoothly, there should be a provision for the resolution of disputes, whether it be litigation or arbitration.
Now, these provisions should specify the warranties you're being given. Is it only for labor, or is it for materials, or is it for both? How long is it for? What do you have to do to make a claim, and when? Do you want provisions for payment and for performance bonds? If so, usually you'll have to pay the premium for them. Under those circumstances, if the contractor still does not want to provide them, you should wonder why. Is it that the contractor is not bondable? And if not, why not? Remember, You are looking for a responsible contractor. Insurance provisions are extremely important. You want the following at a minimum: commercial general liability in its broad form, including independent contractors, completed operations, contractual liability, product coverage, and property damage, perhaps including explosion and collapse, personal injury with employment exclusions deleted, comprehensive auto liability, both owned and non-owned. You'll also want workers' compensation insurance. You'll need a complementary provision also for getting copies of insurance certificates and a representation for the insurer that you'll be given notice of any cancellation. Now, you may want to also have specific clauses as to your remedies for breaches of the contract and for its termination. Now, the short proposal form will not have all of this, while the AIA contract may have much, much more, or perhaps a watered-down version of some of it. However, we've included your must-haves in this video. As always, if you ever need help with any of your contracts, we are here at our toll-free number, 877-241-1600, or at our website, goshlaw.com, GOSHLAW.com.